Okay, now we need the other half of your attention.
Gonna set the building on fire.
All right, we're up to 80%. 85. We're almost there. All right, there we go. First of all, how about Willie Rodriguez? Something else.
He was good.
My only desire was that David Von Kleist's introduction was at least a lot shorter so he could talk a lot longer. Just teasing, David. Thanks for this being here with us for lunch today. Ryan is going to be on probably more in the realm of financial privacy than asset protection, although he'll probably use some of the things.
I'm going to do both.
They're sometimes mixed together. But before he begins, there goes the profit. You know, that stuff comes right off the bottom line. I do have asset protection guides available. I only have literally probably 7 or 8 left. So if you're interested, they're $40. They're written by Ryan and formatted by me, so I get a hair credit, not much. And there really are the good, bad, and ugly of asset protection. It talks about what works, what doesn't work, and how to work in the system that we all, quite frankly, have to exist in if you want to, shop at the 7-Eleven or something. We also have one initial consultation left for this afternoon at 5 o'clock. The first $140 gets that. That does come with a manual. So, it's really $100 plus the $40 for the manual. And that's available at 5 o'clock this afternoon. So the first one with, greenbacks is, oh, we don't have greenbacks. You guys saw Bill Still, right? With that worthless FRN thing that we still take, we'll take some of that from you. And our website's always available. We're always available by phone. You'll probably get me long before you get Ryan until you become a paying client because we've just grown through the roof.
First one.
It's just the way we've got to do things now. He's busy doing the real stuff, and I'm busy doing the secretarial stuff. But anyway, so we've got those things available for you. We appreciate you listening. We appreciate your time, enjoying this fantastic meal today, quite frankly. But without further ado, I'd like to introduce Ryan Fowler. Ryan Fowler is writing a book currently with one of the top asset protection attorneys in the country who has done asset protection for over 40 years. That book will be on Amazon probably in a number of months. He's also helped him write his most recent book, or rewrite it so it can go to hard copy. It actually came out in paperback first and then moved to the hardback version that's much more expanded and updated. David? He just waited. We won't give that out today, but if you'll visit our website, there'll be a reference there too. But beyond that, without further ado, probably one of the leading asset protection consultants in the country, Ryan Fowler.
Thanks, Tim. Oh, stop it. You're too nice. You're too nice. By the way, I'm kind of the absent-minded professor. Tim is the guy that keeps my head on straight. So there's no way I could handle the volume of business we handle without him keeping me organized. So very much appreciate him. Yesterday, I was talking more on how to kind of tell what's good and what not by looking at certain parts of an asset protection plan. So you can know what might get you in trouble or what might not work. And I wasn't so technical as talking about real-world experiences and what's been happening. But today we are going to get more technical. We're going to talk about what works in asset protection, what are some of the specific things that we do. We're going to talk a little bit about offshore stuff, LLCs, limited partnerships, corporations, equity stripping, trusts. And so we're going to get into the nitty-gritty of how to protect your wealth from creditors. Now, creditors, just so you know, a creditor is anyone who has a claim to your wealth. A creditor can be the other spouse in a divorce proceeding. It could be creditors, the bankruptcy trustee in a bankruptcy proceeding. It can be someone suing you and who's trying to get a judgment against you, and then they become a judgment creditor. It could be a government agency, such as our favorite three-letter boys. So anyone that has that type of claim is a creditor. And when I do asset protection, I protect against all creditors, and there's only a few creditors that are not included in that. For example, if someone has a home, I can protect your home against all creditors except for the bank you originally got a loan with. And I cannot, if you don't pay your property taxes, can't protect against that. But anything else, IRS, bankruptcy, in some cases divorce, lawsuits, protect your home. Same thing with other assets. So most of the time when I say creditor, I mean 99.9% of the threats out there are included in that phrase. Now, people, when I first started studying asset protection, I wrote a book on the topic, and what I noticed at some point when I was new to asset protection, I was in the same situation that many of you were in, and that is, you look at all these people saying you can do asset protection through Nevada corporations, pure trust, corporation souls, LLCs, FLPs, that's family-led partnerships, you can go offshore. And there are so many things being marketed out there that, you know, if you're just your average guy that wants to do asset protection but doesn't know much about it, it's pretty confusing and pretty daunting. I've had clients to me that have done some other asset protection plans and gotten burned badly. And I've had plans that I've had to, fix. People that didn't do asset protection, they got burned and then they came to me. So there's a lot of need for asset protection out there. You're really protecting your life savings, but there's so many different things to choose from. So I'm going to give an overview of almost all the entities out there. Really the main ones you come across, and I'm going to tell you point by point what's good with this, what's not good with this, and what works, what doesn't, and why. Now, from yesterday, one thing I talked about yesterday is you never want to use any asset protection program that's on the IRS Dirty Dozen list, or that any type of program that says take this program and you can eliminate or greatly reduce income tax liability. I'm going to talk about these first and then just tell you why it's not a good idea. Anything on the IRS Dirty Dozen list, we have to realize we live. There are people that promote programs that prey on how things ideally should be. And it sounds good to us because, for example, there's programs and they say, well, you have your constitutional right to contract this right, that right, the other right. And it's true. Ideally, we should have those rights. But in the freedom movement, there are so many people getting up and talking about what is right, and there's all this corruption going on, but this is what's right, this is what the law really says, etc., etc. Well, that's true, that's how things should really be. But in the world of asset protection, unfortunately, you have to deal with reality. Because the ultimate test of any asset protection program is if you're in court and the judge puts you on the witness stand and you have to just kind of lay everything out, and they look at everything, how is that judge going to react? And that's the bottom line. So when I formulate my plans, I look at what has happened in the courts. I read court cases all the time. And so I have to formulate my plans based on what's going on in the real world. Now, unfortunately, the courts give precedence to the IRS Dirty Dozen list, and unfortunately, any type of asset protection program that says, hey, do this program and now you don't have to pay taxes, it's customary for after a year or 2 or 3 of them promoting, maybe a little longer, but not much, the IRS comes in, shuts them down, raids the office, gets the client list, and oftentimes starts investigating the clients. So that is not a good thing, obviously, if all of a sudden the IRS calls you and is asking about the plan that someone did for you that is now shut down, and maybe they're just not promoting it anymore, or maybe they're even in jail. Some of these people are in jail. And they call those types of plans abusive tax shelters. So any type of plan on the IRS Dirty Dozen list, unfortunately, the courts pay attention to that, and if it's on that Dirty Dozen list, that's the court's reason to just kind of cut right through that program and call it a sham or whatever. So unfortunately, those types of programs don't work, or these so-called abusive tax shelters, you want to avoid those too, because in the real world, they just don't work. I'll just list real quick some of these abusive, in the IRS's eyes and the judge's eyes, abusive programs. And I can go further into, I can talk about substance versus form conflicts, and I can talk about other reasons specifically why these are not good things to do. But it'd be a waste of time, because suffice it to say, just by being on this Dirty Dozen list or by making these claims, that right there can cause a plan to fail. So some of these plans, and I have had people come to me where these plans have failed and where companies did get shut down. And I don't want to really talk about whether the intentions behind these are good or not, or whether they actually follow the law or not. I don't want to focus on that. I just want to focus on the mere fact that they're not working. And so the 2 biggest ones I've seen are pure trust and corporation sole, and also put another type of trust in there. It's called a self-settled trust. Self-settled trust. Okay. So let me talk about self-settled trust real quick, and then we'll get to some of the good stuff that does work. A self-settled trust, let me define a trust real quick. A trust is a contractual relationship. And I'm sure most people here have heard about trust. Who has not heard about a trust in this room? Yeah, most people at least heard the phrase. When you have a trust, you will have a person with assets. And he's called the grantor or settler. We'll just call him G for grantor. He has assets, and he gives them to another person or maybe a company, which is called the trustee. And the trustee will manage the trust, the assets in a fiduciary capacity for the benefit of a beneficiary. And he's baby B there. Okay. Now, if the beneficiary is a different person than the grantor, then that is called a non-self-settled trust. And you can set up a non-self-settled trust so that it will protect assets. You put in what's called a spendthrift clause. A spendthrift clause is basically language that the trustee can withhold distributions to the beneficiary in certain circumstances, so that if someone sues the beneficiary, trust assets are withheld from the beneficiary, and the creditor that's suing the beneficiary doesn't get anything. That's supposed to be an arrow. Okay, C is the creditor. Right there. That's Mr. Bad Guy trying to take away assets. So he can withhold that. Now that provides asset protection, but one problem we come along with trust is the grantor wants to give assets to the trust, but he wants to keep on benefiting and enjoying the use of those assets in some form. That is a self-settled trust. Now, even if you have the beneficiary enjoy some of the assets, who's someone besides the grantor, if the grantor continues to enjoy these assets, it's a self-settled trust. For example, let's say, and I've come across a lot of people who have done this, let's say you put your house in a trust. And some of these trust promoters pure trust or self-settled trust promoters, they know that in 46 out of 50 states, if you have this self-settled trust, the laws say, and these laws, the trust laws, by the way, say it applies to all trusts. So some people say, well, these common law trusts are outside of the legislation. Well, unfortunately, in reality, that's not the way the courts see it, and the statute says it covers all trusts. So we'll dispose of that. But in 46 out of 50 states, if the grantor continues to benefit from the trust, no asset protection, and the creditor can get assets in the trust. So say you put your assets, let's say you put your home in a trust, and these trust promoters know that these self-settled trusts don't protect assets by law, so they say, well, we'll make your children a beneficiary. But you continue to live in this house that you put into the trust. The Supreme Court has said, and this is widely established in our courts in all the states across the land, Supreme Court themselves have said this: substance rules over form. And what you have to understand, substance is what's really going on, and form is what your trust document says. Now, if the trust document says the only beneficiaries are the children, but you continue to live in the home you put in the trust, substantially speaking, are you a beneficiary? Are you benefiting from trust property? Yes. The substance is you continue to enjoy that trust property, so even though the form of the trust says you're not a beneficiary, substance says you are. And if this trust is challenged in court and you have form saying one thing and substance saying another thing, then a judge will attach a dirty four-letter word to this type of trust, and that four-letter word is sham. Yeah, that's right. So if you're using a trust and you continue to benefit from trust assets, there are a few states that allow self-settled trusts to provide asset protection. There's Nevada, Alaska, Delaware, and I think Oklahoma now too. However, I don't use those types of trusts because there's many other holes in them that I won't go into detail now. But suffice it to say, with a trust, unless you're going to really give away that asset and never benefit from it again, for example, you want to pass it on to your children, which is for estate planning, if you do that, then this trust could stay out, the trust assets stay out of the hands of the creditors. Otherwise, it's not a good way to go. Now, I do use trusts a fair amount. They're not always bad. They are definitely good for avoiding probate. What probate is when you die, your estate, according to the terms of your will, or if there is no will, then according to the laws of the state, called the intestate laws, your state is put under court supervision, and the court controls the distribution of the assets from your estate to your heirs. Now, probate can take a long time. It can take 1 or 2 or 3 years. You know, expenses could be 50 grand, or I mean, it could be up there. It depends. Some really small estates, you know, it's pretty simple, but more complex estates can cost a lot of money to distribute assets to your heirs, and it can take a long time before your heirs get those assets from your estate. So we can use trusts to put assets in these trusts so that when the grantor dies, the assets quickly pass to the beneficiaries without going through this probate process, and it saves a lot of time and money. So that's a good purpose for trusts. Also, trusts can be very good for an extra layer of privacy. And for those of you who weren't here yesterday, privacy is good because when you keep a low profile, you tend to stay out of trouble. If a creditor is going to go after you, they're going to have to spend a lot of time and effort going after you usually, or at least some time and effort. So before they chase after you, they usually do what's called an asset search. They'll use the internet and they'll use other tools to search your county recorder's office to see what real estate's in your name. They'll search, go through bank records, your credit report, and they'll go through all these means to find your assets. If we have financial privacy, if your assets are held in a trust or some other type of entity, you do have financial privacy because they're not in your name. And so if someone's looking at suing you or IRS wants to go after you, they'll try and locate these assets. If they can't find them, well, then you do have a certain amount of asset protection, and maybe that discourages them from chasing you so hard. If they see you have $1 million in assets, maybe even if they're protected somewhat, they're going to chase a little harder to get $1 million than they would to get, you know, $10,000, for example. So privacy is good, and we can use trust for privacy, but for straight asset protection, because people that want asset protection usually also want to continue enjoying those assets, usually not a good way to go for the asset protection component of our plan. Now, I'm sorry, does someone have a question?
Would a rental agreement between the grantor and the trust negate that benefit?
No, no. It's still a... Well, actually, no. Let me think. There are some types of... Yeah, I know what you're talking about. If he puts the asset into the trust and then pays fair market value rent, right, and then his children are the only beneficiaries, right, I think that would hold up, and I've seen some people do that. Unfortunately, what some people try to do is they try to funnel things around so that the rent's used to pay the mortgage that is his mortgage and is therefore benefiting him. So if you're paying rent, make sure you pay rent and you never see that rent money again. The rent will go to your children, for example. Right. So that could work if you just, no funny stuff, and you do it just like that. Now, one other problem with the trust is there's something called fraudulent transfer laws I'm going to be talking about shortly. And when you put assets into the trust, you gift the assets into the trust. There's no consideration. There's nothing of value that the grantor receives to put his assets into the trust. So one problem with trust is if you put assets into a trust and shortly thereafter, or you're already in some type of creditor trouble, someone's chasing after you for your assets, that is much more easily set aside as a fraudulent transfer by putting assets into this trust, even if you are paying a rent agreement, because you did not get anything back from the trust for putting your home in there. It was a gift. So it gets a little complex in that area, but technically under the law that's how it works. What fraudulent transfer law is oftentimes if someone gets in trouble with a creditor, they'll try and get assets out of their name so that if they lose a lawsuit or have a big tax debt or whatever, they won't have much that the creditor can claim. And our courts know about this very common tactic, so they have a body of law called fraudulent transfer law. And this law dictates whether your transfer of an asset to someone else was fraudulent. It doesn't mean you committed fraud, but if they say it's a fraudulent transfer, which is transfer you're trying to make so that you can thwart your creditor's attempt to collect on you, they will actually put the transfer back in your name and let the creditor get the asset. So one of the things in fraudulent transfer law they look at is if you take an asset that was yours and it goes somewhere else, did you get anything back for that asset? For example, if you have a home and you sell it to someone, well, you got money back. So that probably wasn't a fraudulent transfer, you just sold your home. And it makes sense. But if you just give it away to your uncle and then you keep on living in the house, they're like, well, you probably just did that to avoid the creditor. So one problem with trust is because you don't get anything back when you put assets into the trust. If you already are in some type of creditor trouble or shortly will be in creditor trouble and you kind of see it coming, then you're open to this fraudulent transfer ruling. So, but if you do it completely while the creditor sees are calm and you pay fair market value rent and then that stays in the trust or eventually goes to the beneficiaries, then that can provide asset protection. Another type of trust that works is there's what's called a personal residence trust. This is an estate planning tool, and you continue to live in the home, but your only right in the trust is to live in the home, say, for 10 years. But if the home is ever sold, then all the money goes to the beneficiaries, or after 10 years, the trust has to say that you have to move out. And then when you die, or if the the home is ever sold, the beneficiaries get the money. We don't usually use these personal residence trusts because most people say, well, I like to live in the home, but if we sell it, I also like to get the money back. I don't want the money to go to my kids and I never see a penny of it. So you can do some asset protection with trust, but there's just, it's only in narrow circumstances, and there's other things out there that can be used that just work much better in a much broader variety of circumstances. So, and like I said before, trusts are not bad. I use them quite a bit for probate avoidance, for privacy, sometimes even for asset protection. I did do one trust last year specifically for asset protection. But you have to understand how trusts work so you can understand that usually they're not good for asset protection, and there's other things out there that are often better. So that is how trusts work. That's the That's a high and low. That's domestic trust, and I'll talk a little bit about offshore trust later
What
as
about
well.
life estate?
A life estate, that is sort of what a personal residence trust does. And what happens is, if a creditor sues the, I don't know where that eraser went.
It's right there. It's a little far around.
By your foot.
You bend down over, you'll pick it up.
Underneath the easel.
Thanks. This is my absent-minded part coming out. Oh, I couldn't even see it on the floor. Absent-minded professor, I'll tell you. Okay. Anyways, okay, we were talking about trusts, and you were talking about life estates.
Life estate versus...
Okay.
Yes, sir.
Now, you can do a life estate, and see, the reason the personal residence trust worked is because your only benefit in the trust is the right to live in that house. That's it. And so if a creditor sued you, the only thing they can get is the right to live in the house. And unless the creditor is a homeless person or your house is a lot nicer than theirs, they don't want to live there. They just want to sell it and get the money. And so that's why you have some protection. Now with the life estate, if your only right is to live in there until you die, you might get some asset protection as well. But it's weaker because, number one, from an estate planning point of view, doing a life estate makes almost no sense to reduce estate tax. It just really doesn't make that much sense from I mean, there's some benefits, but there's just so many other things you can do that are much better. So I have one thing, when you do asset protection, you always want to have a real good reason for what you did besides just straight asset protection. And when you do a life estate, you really don't have that good reason besides just straight asset protection. Because if you're trying to reduce, if you're trying to reduce estate taxes, a life estate reduces 0 estate taxes. And if you're not concerned and you just want the whole probate thing, then you just do a revocable trust. And so they really question, well, why did you do a life estate? And what that means is, if there's not a real good reason for doing the life estate besides asset protection, you're more vulnerable to a fraudulent transfer ruling. Because a fraudulent transfer is if you do something specifically, basically hose a creditor so they can't collect on the judgment, then if they can prove that that was your intent, then a fraudulent transfer ruling is much more likely, and that's why I usually don't do life estates either. But if you don't get a fraudulent transfer ruling, then it'll hold up just fine, unless they want to live in your home instead of you. So, okay, moving right on. We're going to talk about some real good stuff now. We just got to kind of build everything bit by bit. Okay, we're going to talk about limited liability companies and limited partnerships. No, actually, let's talk about corporations first. Okay, corporations, everyone's heard, Nevada corporations, Wyoming corporations, use it for privacy and asset protection. Now, I'm not going to tell you that corporations won't provide some asset protection, because they will. And yes, you can use a Nevada corporation, and you can appoint, when you form a corporation in Nevada, by the way, for people who don't know, a corporation is a business entity and it's treated like a separate person from you. But it's not an actual person, it's just a fictitious legal entity, but legally speaking, it's treated as a completely different person from you, although it's a company. And so when it holds its own assets and everything, the assets are not treated as your assets, they're treated as a corporation assets, and everything's completely separate. So if you put assets into a corporation, then you get sued. Well, they're not your assets, they're the corporation's assets, and since the corporation isn't getting sued, but you are, the theory goes you have some asset protection. Now, what Nevada corporations do is when you form a corporation in Nevada, you have to list on their website, which everyone can access publicly. You have to list who the corporate officers are. A corporate officer is someone that runs the company, basically. You have a president, secretary, and treasurer. And you can have other officers under them, but those are the big ones. Those are listed on the Nevada website, but Secretary of State website. But the owners of the corporation are called the stockholders. The corporate officers just run the corporation, but the owners are the stockholders, and they don't list who the stockholders are. So the theory goes that you can form this corporation in Nevada or Wyoming, and you can have people that are besides you who act as these corporate officers, but you as the owner of the corporation no one knows about. So you get privacy that way because they just don't know who owns the corporation. Now there are some problems and concerns. And in Nevada corporations, they say, hey, we even can make your stock a bearer share. What a bearer share is it's a stock certificate and it's like cash. If you have it in your hand, well, then you got the money. If you give it to someone else, now they have the money and you don't own the corporation anymore, if that makes sense. So they say, hey, that's even greater, because if no one can prove you don't own this corporation, then they can't attach the assets inside the corporation if they sue you. Now, you can get privacy that way, and privacy is very good. But the thing I don't like about corporations, there's several things. Number one, every corporation, the IRS expects to file a tax return. It's either called an 1120 return or 1120S. And so you'll get privacy from everyone except for the IRS. And they are a potential creditor, as we all know. And if you don't file these returns, then they can say, hey, why didn't you file a return? And now they have a reason to attack your corporation. And also, if there's not assets to pay, they do an audit and they find there's tax liability. And if there's not assets in the corporation to pay that tax debt, they can also go after the corporate officers. So by complying with the requirement, this filing requirement, you lose your privacy to the IRS. You might have it to other people, but you lose it to the IRS. By not complying, you now gave them a reason to attack your corporation, and at least seize assets in the corporation, go after the corporate officers, even if they don't find out who the owner is. So that's not good. Another thing with the corporations is they're governed by a strict body of laws, and in order for your corporation to be respected as a separate entity and to protect your assets, you have to follow what are called certain corporate formalities. You have to have an annual meeting of the board of directors. Anytime you make a major decision, you need to have drafted what's called corporate minutes. You usually need a corporate attorney or at least some forms to do that. You have to do everything in this formal manner. You have to have what's 3 types of management. The stockholders vote for the board of directors. The board of directors elect the corporate officers. Stockholder, corporate officer, board of directors. So you have this structure that's kind of a pain to keep up in addition to your tax return. Even if your corporation has no tax liability or brings no money in, still has to file these returns. So you have all these hoops to jump through. You hoop. And in addition to those hoops, you have to hire these nominee officers in order to get privacy. You have to hire these officers that are listed on the Nevada Secretary of State, their corporation's website, in your state if you want privacy. There are much easier ways to get that level of privacy, and I'm going to talk about LLC shortly, but I'll just mention real quickly. There are some states where you can set up a limited liability company and they never ask who the members or managers are. People will say, well, the Nevada doesn't share information with the IRS. We can set up an LLC where there's no information to share. The state doesn't have anything to share except the name of the LLC and a principal place of business somewhere. And that's all they have. They never ask who owns it or who runs it. So we don't need these nominee officers. Furthermore, limited LLCs, by the way, an LLC stands for Limited Liability Company. And it is not a corporation, but it's a business entity that is unincorporated, meaning it doesn't have shares of stock. It has it's a completely different structure, although in some ways it's similar to a corporation. So with an LLC, you don't have to do these annual board meetings. You don't have to have these corporate minutes. You don't have to hire these nominee officers that are listed on the public state website instead of you. The state never lists the names because they never get that information, and you don't have to keep these meetings. And in one state, for example, New Mexico, once you form this LLC, you don't have to file any report with the state ever. You just form it and you go on your merry way. And they never ask who the members and managers are. So with an LLC, if you want privacy, it's a lot easier to get that privacy with an LLC than with a corporation. And you can set up an LLC so that it's taxed as what's called a disregarded entity. And to make a long story short, a disregarded entity LLC never files a tax return as an LLC. If you have tax liability arising from profits in the LLC, then you report that on your personal income tax return. And I by the way, I have a policy of never telling my clients whether or not they're liable to pay income taxes. That's up to them. I set up the companies. I don't give them tax advice on how to handle their personal taxes. And nor should I, because if I did, you know, I'm not a CPA, I'm not a tax attorney. And if I ever told them, well, you can save income taxes here, and I was wrong, then they could say what I was doing is abusive tax shelter. So it's really safe to keep that separate. And you guys go to your CPA or attorney or whoever, or maybe you can determine your own tax liability, but we do keep that separate. But anyways, with an LLC, tax a disregarded entity, no requirement as an entity to file any tax return. And if there's no tax liability, then there's just nothing reported to the IRS referencing this LLC whatsoever if there's no tax liability from LLC activity. So we can set up an LLC where you don't need to file anything with the IRS. And it's legal, and they will tell you the exact same thing. There's IRS revenue ruling I refer to, which gets a little more complex than what I'm talking about, but it's IRS revenue ruling 2004-77, and it talks about disregarded entities. It actually talks about how you can, normally a disregarded entity only has one owner, but there's a way to get multiple members or owners of these companies and still have it classified as a disregarded entity so that the LLC itself doesn't have to file a tax return. But everything I'm telling you about right now is what the IRS would tell you the same thing. And the reason my programs work is I do everything so that I accomplish a client's goals and get them the protection and privacy they want, while at the same time complying 100% with all of the regulations and all the rules and all the procedures, and just doing everything 100% by the book. And the reason that's so effective is if someone tries to attack your structure, you did everything right. So they have no reason to disregard the structure or do what's called a piercing of the veil. If you run your LLC incorrectly or run your corporation incorrectly, they can argue that the protection it's supposed to provide you, the limited liability, so they can't get assets in the business, or if they're suing the business, they can't get your assets. The court or the plaintiff, whoever the creditor is, they can argue that, well, that limited liability, that protection should not be there. But if you run everything correctly, then it stands up just fine. And that's actually real world experience. I've had clients who've had their companies be challenged and they stood up just fine. So, what's that? It's, and this is kind of a complex ruling, but it is IRS Revenue Ruling 2004-77.
Thank you.
And if you do a Google search on it, it'll come right up. And it basically talks about disregarded entities. There's also on my website, this is a great resource for you guys, www.pfshield.com. If you go to my website, there's a lot of information that kind of keys you into the basics of how LLCs and corporations and all that work. And there's also, on the main page, if you scroll to the bottom, there's a hot topics section. And the bottom of the two hot topics talks about an IRS internal legal memorandum that talks about how the IRS cannot collect against LLC assets for the tax debt of the owner. If the LLC is run correctly, if you run the LLC wrong, they say if you do this wrong, this wrong, this wrong, or this wrong, then they can get into assets inside the LLC. Well, I'm glad they told us that, because they told us what not to do so that our LLC will protect our assets. And this memorandum on my website talks about an actual court case. So it wasn't theory they were discussing. This internal legal memorandum from the Chief of General Litigation of the IRS is talking about an actual court case, a real world circumstance that she's commenting on. This LLC and this internal legal memorandum, if you read the memorandum, is also a disregarded entity, and she talks about a disregarded entity means the entity is treated as non-existent for tax purposes, meaning it's not even there, and that's why the entity, the LLC, doesn't file a tax return. But she talks in this memorandum how the entity is not disregarded for legal purposes. So for purposes of can we get your assets or not, is treated as a separate entity, but for purposes of taxes, in other words, does it have to file its own tax return, is treated as not even being there, and that's why it doesn't have to file a tax return as an LLC. Instead, if you have tax liability from the LLC's activities, you report it on your personal 1040, Schedule C. So, anyways, one other thing I want to talk to you about with the corporation, I guess I should write this up here, huh? Is if your privacy fails. Now, I know there's a lot of promoters of Nevada corporations and other corporations that say your privacy will never fail. They'll never find out you own this corporation. Well, you know, and they say, hey, you know, you can be on the witness stand and they ask you, do you own this corporation? You can say no because you have these bearer shares, and only if you hold the shares in your hand you own the corporation, but if you give them to someone else then they own them, and that person can give them to someone else you don't know, and now you say you don't know who owns the corporation. You know, this is some of the hype given people who sell Nevada corporations. Unfortunately, even though you say that, they can track bank records and maybe use that to prove that, you know, okay, you're a Nevada corporation, all this money was taken out and paid to your personal bank account, you know, or they can use what's called constructive evidence that you own the corporation. Or they can say, do you own the corporation? No. Okay, what is your relationship to the corporation? And then you have to say, well, you know, it's transferring all this money to me, and otherwise you're committing perjury. So they can use constructive evidence. Or maybe you're married and you get divorced and your ex-spouse is now really ticked off, and, you know, they fib on you because they knew about the Nevada corporation. So a lot of times your privacy will stand up, but there are situations where it could fall apart. And unfortunately with a corporation, if you are sued personally and they do manage to connect the corporation to you, then your corporation will no longer protect your assets, because if you are sued personally, or if the IRS comes after you, then to satisfy their debt, they can seize your corporate stock. And once they get, and that's the ownership in the company, once they get 51% or more of that stock, they can vote to take the company and get all the assets out of it and shut down your company, and then they just get everything that was inside of it. So that is the shortcoming of the corporation. Now, another problem with corporations is if you put assets into a corporation, there's no taxable event. But if you put an asset into a corporation and it appreciates in value, like a home, and then the home goes up in value, and then later on you want to take it out of the corporation, you have to pay tax on any appreciation in that asset's value. If you set up a limited liability company or a limited partnership, you take the asset back out. Even though the asset went back up in value, no tax liability. It just goes back to you and you're okay. And so, my opinion is there's some discussion in, you know, among these groups about whether there's tax liability or not. Well, hey, if you can just sidestep that fight and not even have the IRS fight you on that issue, isn't that the better way to go? So let's sidestep the issue so we don't even have to fight with anyone about it. Let's do it so that they're not going to question whether or not we have tax liability. Let's say, yeah. You had it in a limited partnership or an LLC, you took it back out, that's not a taxable event for LLCs. But with a corporation, it very likely might be. So, corporations, although they can provide asset protection, there are some things about them that are not as good. Now, we will talk about some really good stuff. We're going to talk about limited liability companies and a little bit about limited partnerships. Now, the LLC, Limited Liability Company, I guess I'll put that up here. Dug myself in a corner because I'm left-handed and okay. Here we go. LLC. Okay, now I've already talked about some of the virtues of the LLC. In some states, not all states, in some states, you can get a lot of privacy. In most states, much easier to run and set up than a corporation. The one big thing I have not talked about yet is there is a statutory law in every state except I believe Pennsylvania for LLCs that is called a charging order provision in the laws of each state. what a charging order is, and we call this charging order protection even though it technically isn't. What happens is if someone sues you personally and you have your assets in an LLC, and this is the same thing, there's another type of business entity called a limited partnership, and this applies to limited partnerships as well. Someone sues you, or the IRS, or just anyone goes after you personally, your assets are in this LLC or limited partnership. By law, they cannot get the assets in the limited partnership, they cannot gain control, or the LLC, they cannot gain control of the LLC or limited partnership, and they cannot get any ownership of the LLC or limited partnership. The only thing they can get to help satisfy their claim to your debt, so now a creditor, is what's called the charging order. And the charging order is an assignment of rights, so they now receive the right to receive profit from the company instead of you if profit's distributed. Now, it's not a very effective remedy. In fact, I work with a gentleman, he's had almost 20,000 clients in his 41-year career. And in that whole time, he's only had 2 or 3 creditors apply for this charging order, this remedy where they get the rights to profit instead of you from the company. Out of all those clients, why did so few creditors choose to get this remedy where they get the right to profit? Well, the reason is it's really a lousy remedy for the creditor. Because since they cannot control the company, whoever does control the company just decides to keep all the assets within the company and not distribute it. So they get nothing. And in certain circumstances, not always, but in certain circumstances, there is an IRS ruling called IRS Revenue Ruling 77-137, and it says if someone has the assignment, receives the right to receive profit from the company, that they also receive the tax liability for that profit even if they don't get the profit. In other words, every year there's going to be if there's profit made by the company, even if it stays within the company, the person that has the right to receive that property, if distributed, has to pay that tax liability, even if the profit is not distributed and stays within the company. And this friend of mine, there's one situation, he set up a limited partnership, which in this instance works exactly like an LLC. And the IRS got a charging order against one of his clients. I don't know, it was like $30,000, $40,000, I can't remember the exact amount was the debt. But this limited partnership had significant profit. They kept the profit within the company. The IRS had the right to receive that profit if distributed, but because they had the right to receive the profit, they have to pay tax on it whether or not they actually receive the profit, because the manager of the company can keep profits within the company and not distribute them. The partners still pay the tax liability. So they sent a tax bill to the IRS to pay the tax on this guy's partnership profit. K1. Yeah, K1. The IRS dropped the case. So that makes our job fun. And strange but true. So, you have some tools with the LLC. They're not only a lot easier to set up and run, but you don't need to jump through the hoops of setting up these corporate officers for privacy, because they just don't ask for that information in certain states. Much easier to run, and you have this charging order protection. Now also, let's say you have assets inside of this company and you need to get some money out of there, but they have this charging order against you, so if you take money out as profit, it's going to go to the person who has the charging order. Well, you can get money out of the company in ways besides a distribution of profit. The company can loan money to you that you pay back after everything's blown over, or maybe you do some type of contractor work for the company and charge for services. Now, it's not always appropriate to do that. We have to look at the situation and see how aggressive this creditor is, but there are other ways to get money out of the company besides a distribution of profit. So that makes it even more distasteful for them to want to get this charging order. And basically they they're just really in a difficult spot if any creditor wants to get your assets in the LLC. They're really between a rock and a hard place. Now, I will not say that every asset that the asset protection plans I do or anyone does is 100% bulletproof. Because you just don't know what's going to happen. We can have a 757, fly into this room in the next 5 minutes. So I won't say anything I do is 100% bulletproof, but I will say that at this point I think I have around 300 clients in my history, and I've never had a plan fail. And I'd say about half of them that come to me when they're in some sort of trouble. So these processes are effective. Now I'll just talk about the difference between a limited partnership and an LLC. And does anyone know how we're doing on time, Tim?
You're over.
Oh, darn it. Okay. Okay, I'll skip the limited partnership. Limited partnership is, just suffice it to say that in most, not all situations, but most situations, an LLC is what you want to do. I formed over 100, probably about 150 LLCs last year. I formed 10 limited partnerships approximately. So it really depends on your situation, and what I'm telling you is really not a do-it-yourself thing, because you got to set up an LLC and then you got to research your state laws and look for compliance. Some assets I don't put in an LLC. If you have a mortgaged house or mortgaged piece of property, I rarely put that into an LLC unless it's free and clear. There's just so many things you have to look at, and you also have to look at how to handle this LLC. So if you can get financial privacy legally, how to do that. There is a way, for example, to set up a bank account that is legally not connected to you, but you enjoy beneficial use of it. We do that with an LLC and a trust. It has to be a non-interest bearing account, but there's ways to do that. And I think the only thing I'll cover real quickly is equity stripping. And I'll talk real quick about offshore planning. I'll keep this about 1 or 2 minutes on each topic. Some assets, because they are encumbered by debt, you have like a loan on your home or some real estate, you can't transfer to an LLC, because if you do, the loan agreement you signed has what's called a due on sale clause. And that says if you transfer your property, that the bank reserves the right to call the entire loan due, usually within 30 days, and if you don't pay up, they reserve the right to foreclose. Now, they may not find out you did the transfer. They may not care as long as you're still making the payments. But if they do care, then you could lose the property or have some big problems. And a lot of times what they do, and I know at least one person that something like this has happened to, is they'll threaten to foreclose, but instead they're really just trying to milk you for another 10 or 20 grand to keep the foreclosure from happening, to scare you. So maybe they'll do that just to milk you for money. Even if the foreclosure doesn't go through, and I don't want a client to lose 10 or 20 grand. I would consider that a big mistake on my part if I exposed them to that type of risk. But there is a federal law called the Garn-St. Germain Act, and it allows you to do certain things that do not trigger a due on sale clause in a loan. You can transfer your property into certain trusts for privacy, which probably won't give you a whole lot of asset protection, but you do get privacy. And you can put additional liens on your property without triggering a due on sale clause. Now, what a lien is a lien is an economic right in your property to secure a debt or an obligation. For example, if you have a $200,000 home, you take out a $150,000 mortgage. A mortgage is a lien. The bank will put a lien called a mortgage, that's a type of lien, on your home for $150,000. What that means is if you don't pay the loan, then they have the right to foreclose on their home and collect the $150,000, which was the amount of their lien. In other words, they own $150,000 if you do a $150,000 bank loan. Now, let's say, for example, the IRS comes along and puts a federal tax lien on your home for 200 grand. Your home's worth 200 grand, but you already have a lien on there, this mortgage, for 150,000. And then they foreclose and the property sold for 170,000, sells for less than its current value because it's just a quick auction. Who gets the first 150,000? The bank. The IRS's lien was 200,000. How much do they get? Well, they get 20,000. Okay, because that's what was left over. And then after that, the lien's extinguished, and tough luck. It's liens, except for property tax liens. Liens are generally enforced in the order that they are placed on the property. Same with the IRS. Someone trying to sue you. anything else. So what we do is we have a system where we put a valid lien, and there does need to be a valid reason for the lien, but it doesn't need to be because of a debt. The definition under fraudulent transfer law, which is a law we need to talk about when we're doing asset protection, says a lien is economic rights to property secure a debt or an obligation. So if you want to put a $200,000 lien on your home, it doesn't mean you have to come up with $200,000 worth of cash. You can do some type of obligation as long as it's an honest to goodness bona fide obligation that's values approximately to the value of the lien. We can take your piece of property and $200,000, we can put liens on it till it's encumbered to $300,000 in case it appreciates. You know, the home or other asset appreciates in value. Then, if a hostile lien, like federal tax lien or judgment creditors lien, any lien like that comes on afterwards, guess what? They're out of luck. Their lien does not attach to any equity. So, if they tried to foreclose on the property, they wouldn't get anything except a $3,000 bill for holding their foreclosure auction. If the property was sold, the first lien holder gets paid, the second lien holder gets paid, which by the way is a company that is friendly to you, and that can loan you back the money, or basically the money, you don't own it per se, but you still enjoy the benefit and use of it, which really what you want. As long as you set this up so there's a valid obligation or loan of money behind that, when you sell the home, the money on top of your bank loan goes to a company that's friendly to you, and you've kept your assets even though these other liens came along. They go the way of the wind because you did a fair market value sale and there was just no money left over for them. So we do that. Last thing I'll talk about is offshore planning. I'll be very brief. I will just say with offshore planning, and then I'll do answers and questions very quickly. With offshore planning, be careful. I do offshore planning for some clients. I would say the poorest client that I ever had that I did offshore planning for did about $350,000 a year. So it's not for your average, not for most average people that just make $50,000, $60,000 a year or whatever. The reason you do offshore planning is so you actually get your assets outside of the jurisdiction of a U.S. court, and it's because your assets are worth so much that a creditor may fight really, really hard to try and get those assets. Usually domestic asset protection, even for high net worth clients, I would say more than often than not is plenty sufficient. But if you go offshore, there are almost always, with very, very, very few exceptions, a requirement to report the transfer of that asset offshore. If you have a bank account or multiple bank accounts that altogether in the aggregate have more than 10 grand, you have to report it. If you have a company offshore that you have an interest in, you have to report it. If you don't, then not reporting this is a crime which the IRS and other agencies do aggressively pursue. You look at I think 2004, everyone's seen this statistic, 63 million non-filers, about 250 tax evasion indictments. I mean, drop in the bucket, 44 indictments for failure to file. But if you look at these tax evasion indictments, they really go after the guys that are going offshore. And it's just because they have so much more to pin on you to put you away for that much longer. And quite honestly, if you go offshore and don't report it, the IRS really starts salivating for that type of case. That's a case they really like to go after. So if you do go offshore, make sure you report. Don't go offshore for privacy, because if they find you out, they're going to chase after you a lot harder. You can get stronger asset protection. But, for example, a basic asset protection plan domestically I'll set up for $2,000. Offshore, you're probably looking at a minimum of $5,000, but usually closer to $10,000 or $15,000. It's just because there's a lot more to go through. I have to hire someone offshore that, will administer the plan for you, even though I set it up. There's a lot higher fees going to these offshore havens. There's more reporting reporting requirements. And quite frankly, the stakes are higher, because if I screw up, then the penalties for not reporting or doing things wrong offshore are higher, and so the cost goes up all around. So if you're going to go offshore, I'm not saying it's bad, but number one, you should be pretty wealthy, at least net worth of $500,000, probably appropriate for $1 or $2 million and over. And be careful. And anytime I do offshore planning, I also work directly under an attorney so that the whole thing's covered by attorney-client privilege. Meaning if they put you on the witness stand or me on the witness stand and ask us about the formation of this program, we claim attorney-client privilege, and then we say, I'm sorry, that's privilege, and the courts will respect that. So that is an overview of the ins and outs of asset protection, what doesn't, what works, what doesn't, and why. Everyone, feel free to go to my website. There are some court cases on there. My asset protection book goes over plenty of court cases, statutory law. Everything I do is backed up by what is happening in the real world, and that's what you need to do in order to find out what's going on. Don't just listen to something that sounds good and say, well, what law is this based on? What court case is this based on? Okay? So, check out my website. You've been a wonderful audience, and I'll open the floor briefly for questions.
What would be an example?
Thank you. Hold on, just let it calm down a bit. Thank you.
What is an example of the document other than money being transferred that you would report against the property?
Say that again?
In the equity stripping process, what is
Deed of trust or mortgage, depending on the state.
right, other than the transfer of money, that obligation?
Oh, you do the obligation is based on a contract, or a debt instrument is usually a promissory note.
Right.
Yeah, so it's usually just a contract, and for example, very common, I'm a corporate officer on several corporations, and very common for me to get a lease agreement for an office building in front of me. And in this contract, this lease contract, they usually have what's called a lessor's lien, where the lessor, that's the person leasing property to my company, says if you don't honor this lease, we have a lien on your furniture and other property inside the building, so we can take it if you don't honor this contract.
UCC1?
Yeah, UCC1. Yeah. So, which is used to record a lien on personal property as opposed to real estate, which gets county recorder's office and a deed of trust or mortgage. So there is no actual debt there. This company that is leasing property to me did not loan my company a single cent, but I have an obligation to honor the terms of the lease until 3 years or 2 years or whatever is up. And so that is an obligation-based lien, and that happens in the business world all the time.
And so during a foreclosure, that obligation is still out there?
Yeah, that's right. They still have a claim to it, just like a regular lien.
So
a lien is a lien.
Would they pay that difference of money to that person?
If there's a clause in there that happens upon sale of the property, then yes, absolutely. Yeah, that's correct. Unless you satisfy the obligation before then. And yeah.
If you've already been operating as an LLC in a state, Wyoming,
Okay.
a state that does reveal who the owners are, the members are, can you transfer like to New Mexico for more privacy without it being a red flag issue?
Are you conducting intrastate business? That's business within the state.
No.
Okay, then.
Did you say intra or inter?
Intra means doing business
No.
within that state.
Oh, yes, within the state intra, yes.
So you are doing business within your state with other companies or people?
Yes.
Okay. Does your business have significant assets in it, like hard assets?
No, not really.
Okay.
Our reputation is our best.
Okay. Well, here's what you could do. If you form a New Mexico LLC or an LLC in another state where you get a lot of privacy, and it's doing intrastate business within Wyoming, then Wyoming requires it to register with that state and list who the members and managers are. But in that case, we can make the members and managers trusts or other LLCs where they don't know who the members and managers of those LLCs are. So we can do that. However, and also you can take your existing LLC and merge it into a New Mexico LLC, but they still have a trail connecting you back to your current LLC. You might just want to start a fresh one.
Well, an attorney set it up for us, and after listening to you yesterday and today, I don't think we're getting the full advantage.
Very, very, very few attorneys understand asset protection. They don't teach asset protection in any law school. Why? Because asset protection shows people how to protect themselves from lawsuits. And how do lawyers make money? They make it from suing. And who makes these law schools accredited? The American Bar Association. What is their job? To make sure their members, lawyers, make money. So, if they taught asset protection in law schools, they'd be taking away business from members of the American Bar Association. There'd be less lawsuits. There'd be less people to, and see, you have to hire a lawyer that's a defense lawyer as well as a plaintiff's lawyer. You'd be taking away work from both of them because there'd be less lawsuits. And that's why, in fact, I know a gentleman that has a law degree, master's law degree, PhD, and an MBA. He's an emeritus professor at Northwestern University, very prestigious university. He's a professor at another one. He asked the law professor, hey, I should teach asset protection here. And this guy is just so high up in the legal community that any dean of a law school should be thrilled to have him teach a class. The dean was like, I don't know if we need that. Why? Because he knew the American Bar Association, which accredits his school and says, yes, this is a valid law school, would be really ticked off if they started teaching something that would take away jobs from the members of the American Bar Association. So that's why very few attorneys understand asset protection. Oftentimes they do work under an attorney to get attorney-client privilege. And sometimes there might be unauthorized practice of law issues. So I don't always work with an attorney, but I sometimes do, often do. And that's why your attorney didn't really know what he's talking about. Yeah.
We'll be in touch with you. I got your cards.
Okay, cool. Any other questions? Yeah.
Does tax lien have priority over conventional liens?
Property tax lien will be first in line, but like any other, like a federal tax lien is just has priority in the order it went on your property. So if you have two liens filed before that tax lien, well, the federal tax lien is in third place, and if there's nothing left over after these other two liens, then it's a worthless lien. Yeah. And anyone else? I guess everyone's filing out. Thank you guys, you've been great. Thank you.